And it's now recording. So for the record, this is a public deliberation in Board of Appeals case number CBA-25-019. Today's date is June 25th, 2025. I'm Joseph Evans. With me are board members Deborah Dobkin and Brian Pennington. And as I indicated, we're here to deliberate in this matter. This is an appeal from a letter from the Baltimore County Department of Planning dated January 23, 2025, in which the director, Stephen Lafferty, advised the appellant, which is 8635 Loch Blvd, LLC, that the Department of Planning would not institute a map correction proceeding as reflected or as provided for in Baltimore County Code 32-3-231, and that the appellant or the petitioner had requested that Mr. Lafferty and the Department of Planning institute a map correction because of the claim was that there was a technical defect in the map as created by the Department of Planning following the 2024 Comprehensive Zoning Map, CZMP process program, something, CZMP. And and Director Lafferty indicated that the petitioner could petition this board for a review of that decision. And that's, I think, the procedural posture. Is that correct? Did I get that right?
I believe so.
more or less, good enough for government work. Anyway, so that's where we are. And does anyone want to begin?
I think the first issue that was raised that we have to deal with is whether this matter is properly before the board. I think the county raised the issue.
Yes. And what I thought, did the county raise it or did People's Council raise it? Anyway.
Somebody raised it.
Somebody raised it, yeah. I'm not sure I exactly, well, what is the argument that we don't have the authority?
I think the argument was that it's not and I might be confusing the arguments, it's not a third method of rezoning, and that if the only remedy, if it is a decision of a director and we find the director was wrong, our only remedy is to remand it, and that comes not just procedurally as a decision, but by the very nature of it is a substantive decision as to the mapping issue.
Right.
But for what it's worth, I think we have the authority to review a decision of the director.
As do I, actually.
I do as well. And even in the director's letter, I mean, they relied on the director's letter stating they have the right to appeal to the Board of Appeals. I mean, they relied on that.
Right. I don't. I mean, I understand the notion that there's a certain unattractiveness in associated with us remanding, and then the director would have to institute the procedure, and then we would then have to rule on whether it was done correctly. There's a certain I mean, that is a little uncomfortable, but I don't think it's, I mean, I can imagine situations where we would have the director institute the procedure, but we would not necessarily grant the map correction anyway. So, you know, I was unmoved by that argument, actually. So,
So that was the first issue I thought we had to decide, which we have.
mhm.
And I think the thrust of the property owner's argument was that the flaws in the GIS system are so great as to outweigh the applicant's responsibility for identifying the property that's to become part of the issue.
Right. Now,
And in my mind, even though I do agree the GIS system is a mess, I don't think an applicant can abdicate its responsibility for fully identifying the property that they want to be considered on the maps. And I did not find the case cited by appellants, which was unreported and Reservoir Limited Partnership. I did not find that persuasive. In that particular case, the property was fully described by deed description and or the inclusion of a deed. And here there was, you know, each of these parcels is discrete, has a discrete tax ID number, is included in the deed. So I don't think the flaws in the system are a shield.
right. So the flaws in the system are the flaws in the system for everyone. If we were, I mean, I'm very, very, very reluctant to make sort of floodgates arguments about anything, you know. I think that's usually not a very compelling argument, except here, I sort of think it is. I mean, if we were to say here that the GIS system is so flawed and inept and unreliable that we can just add a third property to a CZMP finding. I mean, where does that lead? I mean, really, I mean, again, I'm usually reluctant to argue about, to resort to floodgates arguments, but that would be a floodgate, it seems to me. I mean, that would open the doors to just everything.
Well, and I kind of look at it a little differently, having been in this situation dealing with the GIS system and the maps, is that an applicant in this situation has the opportunity to rectify the ambiguities of the GIS system by providing better information.
That too.
And
I'm not.
The flaws could be in the underlying property database that the county builds on.
Right. I'm not unsympathetic with the situation. I mean, if I were out there practicing in the field, I could see myself making the same misstep, I guess. I don't think it's particularly, I mean, I could, as I say, I could see myself doing the same thing that happened here, but I just, this is not I mean, the bottom line is, it's just, to my way of thinking, is not a technical drafting error. This was simply the failure to include a property in the CZMP application. That's not a drafting error. That's an error of a different sort. So I thought the witnesses were all very, very good, but I mean, I just don't. I mean, I don't see how this can be attributed to the Department of Planning. Would be my view.
Mr. Pennington, are you still with us? Brian, do you have an opinion?
I do agree with Mr. Evans. I mean, it all comes down to the technical drafting error issue. And just based on the testimony and everything that happened, I'm not sold that it was a technical, that it's considered, what happened here is considered a technical drafting error. It just seems more of, I guess, in lack of better terms, an oversight. I mean, obviously, just in looking at all the things, and you mentioned the tax ID issue. I know there was issues. I have in my notes that there was tax ID issues were a little confusing. The GIS issue, but still, I mean, it comes down to, I mean, everybody, as Mr. Evans said, everybody's working with the same systems. And I just don't feel like what happened here is, under the law, is considered a technical drafting issue.
Right.
That's
right.
Okay. Sorry.
Yeah. So our decision is that we do have the authority, or I don't know if it's a jurisdictional question, but we do have the authority to reach a decision here. And our decision is that this was not a technical drafting error of the sort that's contemplated in the code, which incidentally moots out the first issue, because of our decision. So the decision is that we would rule against the petitioner in this matter. And I think that's that.
Do we simply affirm the letter of the director? The decision of the director? Is that where we end up?
Sure. Sounds good. Yeah, we affirm the letter for the reasons stated in the letter. Okay.
Easy enough.
Anything else we need to discuss for the good of the order here? No. Okay, well, we will then issue a decision promptly, and we will adjourn this public deliberation. Okay?
Again, I apologize for my tardiness this morning.
No problem. It all worked out.
Stay cool.
It's
Stay
all good.
cool. Have a good day.
Have a good day, everyone. Yes. Bye-bye.